Good morning. Today I am going to discuss with a very good judgment which deals with how doctor evidence should be appreciated. Number one, that is primary ratio which you have to look into. Others are high academic interest ratios. What about Redzgeci? If anybody wanted to really understand what is rule of Redzgeci as per section 6 of Indian Evidence Act, and then the question of arises last seen theory, everything was here, but you cannot refer this judgment except for this purpose that doctor evidence should also be because the case finally conviction was upheld. However, death sentence was reduced considering the behavior of the convict even after conviction. All these things are there. You can go see. DNA profiling of rape accused by medical practitioner. Effect of omission. Positive result of DNA test constitutes clinching evidence against accused. Lapse or omission to carry out DNA profiling by itself, however, cannot be permitted to decide fate of trial for double offense of rape and murder. So here this ratio is also important because they say that they have to produce positive result, that means profiles. They have not produced profiling profile. However, they say it is also. Then this is case AIR 2022 Supreme Court 2396 Virendra vs State of Madhya Pradesh. The accused was tried for 302, 376A, 376 Class 2, POSCO Act and Evidence Act were discussed. Here this is most important. Homicidal or accident, medical evidence. Opinion of doctor given along with post-mortem report carries great weight for arriving at rightful conclusion as regards nature of death to be homicidal or accidental. However, court cannot abdicate its function as ultimate opinion. Like any other evidence, expert opinion also requires proper appreciation of at the hands of the court. This is what they say. Then I have already read about a DNA test. Profile should be filed because this is a grave offense. They have not given much importance to that. Then you see here last seen theory. Here also last seen theory, because it was during night hours, they have accepted the last seen theory. Then one more, the grandfather of the victim evidence that he sent his grandchild for purchasing BD. So that evidence was accepted. And another thing, Redzgeci. Redzgeci means one of the witness, independent witness, saw the accused coming out of a place that he was dusting something from his dresses. That is called doctrine of Redzgeci, evidence of independent witness admissible. Redzgeci means though irrelevant, but it is relevant for so many purposes. That is called Redzgeci evidence. Then chance witness. That is Redzgeci evidence. Chance witness, independent witness. Chance witness surprisingly was present witnessing certain things is called chance witnesses. Then what happened? Then question arises. Uh, then they say blood-stained pant was seized from the accused. The body was recovered from a highly dilapidated building. That means the place which was not known or exposed to anyone. That is only 27 recovery you have to attack. Here that was there, they say. But however, the blood group was not detected. The Supreme Court says it is not uh, that is not giving any gap of chain of circumstances, because it is circumstantial evidence. There should be chain of link. There should not be any gap between the link of the circumstantial evidence. Then another important aspect was also there. This is also 2006 AAR SCW 5300 was followed, wherein they say the accused did not given proper explanations about the incriminating evidences. Because you simply say it is false, I do not know, that is not sufficient, the Supreme Court has said. Then question of arises. Finally, the advocate seems to have argued that at the time of committing rape, he pressed the neck. Unfortunately, she died. Therefore, there was no intention. That was also not accepted. They said, no, you are aged 25 years, the child was only 8 years old. Therefore, pressing the neck itself, there was intention to murder. That was, they say. Then finally, rarest of rare cases, they have said, then finally reduce the sentence, death sentence to. So very long judgment. Again, I will say that AAR 2022 Supreme Court 2396, Virendra State of Madhya Pradesh, 3 judges judgment, and you see several judgments were followed. This judgment runs how many pages? This runs up to 2426. 2396, so near about 30 pages are there. But you must go through every page, every paragraph. It's very deep discussion is there. Those who are pursuing postgraduate in law must definitely go through the judgment, which will give you somewhat strength to write project report, dissertations, what not. It's not that you may not chosen the crime subject or whatever it may be, but if you are choosing some other subject, you must understand how the judges wrote the judgment, in what analytical way when they are about to confirm the lower court judgment. And the question of death sentence conversion into life, rarest of rare cases. They have seen. See, so many things are there. Number one, doctor's opinion should be treated as ordinary evidence and should be appreciated. Number two, they say that last seen theory, then resgesi evidences, 27 recovery at the place which is totally concealed, not exposed to any persons. That was there. And recovery of blood-stained dress, which opinion of forensic was that it is human blood, but blood group was not detected. That was also rejected. Then finally they said that pressing the neck is not intentional, and that was also not accepted. Finally, the Supreme Court, however, considering his age, simply converted the sentence to death to life imprisonment as the rarest of rare cases. 1 minute, I want to know what will be the Finally, they say committed to that of imprisoned for life with stipulation that he shall not be entitled to premature release or remission before undergoing actual imprisonment for a period of 30 years. So that is the judgment. Best